Yes.
Adjournment request, if any, from item number 1 to 4. From item number 5 to 13. From item number 18 to 33.
Item number 32, Malas, I seek an adjournment for today. I had circulated the adjournment slip yesterday.
All right. Yes. Give a date.
Yes.
16 June.
Item number 27 and 28. Adjournment status, it has already circulated.
Adjournment slip has been circulated. All right.
Lordship,
4 June.
in item number 24, we have circulated,
Huh?
25, Lordship. We have
Just a minute.
circulated the-
25 also you have circulated this slip. All right.
17 June.
May I please, your lordship, item number 22 with 22 and 23 with the consent of the other side, I beg to mention adjournment for today only, your
All right.
lordship.
17 June. Anyone for 33 and 34?
In 34, who is appearing in item number 33? In 34. Kar dena. Adjournment slip has been circulated. 34. Give a date.
4 June.
Please, Lordship.
Yes.
So with the consent of the other side, I beg to mention item numbers 38 and 39.
38 and 39.
Lordship, no adjournment slip has been circulated, Lordship. Lordship, this matter is led by Mr. P. Naik, additional AG, Lordship. He's not well, Lordship, and we've taken consent from the other side, Lordship.
Mr. Indranil, you're appearing in this matter. You're not well?
I'm here before your lordship.
But then
Ah,
Mr. Nair is not well.
That's all right. May I pray for her?
Nair.
We have a bit of an urgency. If it is not inconvenient, my lord, can it be on either 6th or 8th of May?
Of May.
May.
Why not? Now leave it for 8th. You can have it on 6th. देखिए it has been made on behalf of Mr. Naik, Additional Advocate General Assam, for adjournment on the ground of his indisposition. Stop. Let both the writ petitions, namely so and so, be listed on 6th of May.
Right.
Item number 10, where I have filed an affidavit, my lord. I say, my lord, that affidavit.
Item number 10, what have you done?
I have filed an affidavit, my lord.
Yes.
It's not in the record, my lord. I pray that it may be called for, my lord. Obliged.
Not be here tomorrow or on Monday.
Then Tuesday, my lord.
Do it on Tuesday. That's about that 121-kilometer stretch.
Yes, ma'am. That
Forest
not in-
clearances.
Not in England.
We must have the copy of that clearance.
Yes, ma'am, I have already annexed, my lord, in that.
Inform the other side, it shall be listed on
Next Tuesday or.
Tuesday. Tuesday.
You were mentioning.
All right.
28 April.
Lordship, I am appearing for NHA, Lordship. I have also filed my affidavit on in.
All affidavits which have been filed should be.
My name
annexed
should
to
be taken on record. Lordship.
Give your slip, no? It shall be there on record.
28, my lord.
28
Much obliged.
Tuesday.
28. Let this case be listed on 28th of April.
20
Inform the other side. Mr.
My-
Chaudhary is appearing in this.
Right now.
Can it be on 38 because I'll not be available on 28 here, Lordship. Can it be on 38?
All right. All right, Mr. Goswami.
Much obliged.
30th.
Obliged.
Any other request? Daily list for orders, item 1 and 2.
The report has come.
Yes, Lordship.
It
as-
says so, my lord.
Then decide कर देंगे. Admission लगा दें. More than 20 years, but less than 25 years on the date of examination. No, उस दिन date of occurrence. This report doesn't mean anything. देखते हैं. We'll keep it on some other day.
मला कॉपी में काढली
The age is more than 20 years. is that the date, is that the determination with respect to the date of occurrence?
Examination, Lordship.
Examination.
Date of
No,
examination.
date of examination, use 25 years.
20 or
Actually,
You may not be having a copy of the report.
He's not really asking for it.
We haven't got the copy, my lord. Let a
this-
copy be furnished. We will address this honorable court on the next date, my lord.
Since this has come under seal and cover,
Yes, ma'am.
so you can have a look at it. Show it to them.
Oh, and
Let's-
we can take note of it also.
Why not?
Oh.
Why not?
No, this is seal cover matter.
You can make a note of it. लिखिए, in view of the ossification report of the superintendent of Gauhati Medical College and Hospital having been received, let this case be listed under the appropriate heading on. We give it next week,
My lord, let it be May, my lord, somewhere.
first, second, जब भी करना हो,
Lordship, 5th May, Lordship.
5th of May,
5th of
5th of May.
Much of.
Obliged.
Item 3.
सब बहुत delay है.
Reject कर दो.
No, opposed. Liquidation government. Open for election, they were not appointed, interfered, then in the year 2015, the litigation paper. इसके बाद they have come saying that for you, your firm, so we want pension, पुराना pension. तो उसको पुराना pension दे दिया. इसके लिए वो they have चलें pensions में, pensions में.
तो ground दिया है.
कुछ नहीं है. 23 के बाद कोई explanation नहीं.
There's no explanation whatsoever, Mr. Khatmeyer. We reject this. Vijay, take it from. The application is rejected.
Item 4.
The Lordships, my lord,
Hemant
in
Samatli.
terms of the
In
office
Silicon.
note dated 23rd February, my lord, notice.
What is
has
it?
Notice has been served through the Jari Karak of the District and Session Judge Dhubri. Office report, my lord, reveals.
It appears that respondent number 1 has already been served. However, there is no appearance on his behalf today. To give one more opportunity to the respondent number 1 to contest this application seeking condonation of delay of 478 days in preference.
148 days.
448?
248.
No, 478 days. Which file are you referring to?
Yes, my lord.
478 days delay in preferring the appeal. The matter is adjourned to. You will take something in late May, in first week of May, or maybe second week of May.
4th May.
इसको लिखवा देना.
नहीं लिखा. 23 के बाद कोई reason नहीं.
Item 5.
Also, item 5 is connected with item number 6. In 6, we are challenging the clause 17 of the Assam publication. And the last occasion, they have asked for time for.
Lordship, we've communicated with the department, Lordship, we've received instructions, Lordship, last evening, which is not appropriate, Lordship. Lordship, sometime may be granted to file an appropriate affidavit, Lordship.
No. See, we were made to understand that you're coming up with a new legislation,
Lordship,
doing away with the rigor of section 17
Lordship.
of the control unification order. I think Mr. Nayak had informed on the other day that there is some, notification which says that it can be done in the meanwhile. Till the time proper legislation comes, are you aware of all this?
Lordship, I'm aware, Lordship, but whatever we've received last evening, Lordship, this is not the proper one, Lordship. And how should I have a discussion with
Like,
Mr.
as prayed
Nayak,
for on
Lordship?
behalf, as prayed for on behalf of the state and agreed to by the council for the appellants and petitioner in the two cases. नहीं, ऐसे लिखो. इसमें WPC में लिखना, as prayed for on behalf, WPC number 6038 of 2025 में लिखना, दूसरे को उसके साथ लगाएंगे. As prayed for on behalf of the state and agreed to by the council for the petitioner. Let this matter come up for consideration on 25th of, on 25th of May. Stop. Let WA number 248 of 2025 be also listed along with the aforementioned writ petition. on the same date. Listed along with, okay.
Item 7.
Lordship, I could.
What is there, Mr. Nath? You're not doing it. Then we dismiss this petition.
I could.
Otherwise also, where is the perversity? We may have had taken a different view, but you're not inclined to argue this case. I mean, your client, we are talking about state, we are not talking about Mr. Nath.
I have served the copy yesterday. I have filed it in the morning. I have an extra copy of the I. The 48 days delay is there. I could serve the copy yesterday to the other side.
Your response affidavit, Mr.
I
Borpatra.
have the extra copies.
IA is not before us, it has to be registered. So next day it will come and then only we will ask them. If we condone the delay, then it's all right. 48 days we are going to condone, you know that.
My Lordship may fix a short date so that the matter comes list in the.
Yes, we'll be fixing next date. Here,
Because of the process.
Mr. Nath,
Time taken, my lord.
learned senior government advocate Sam submits that the necessary interlocutory application seeking condonation of delay of 48 days in preferring the appeal has already been filed. However, the IA is not on record. Let the same be placed on record by the next date. In the meantime, if at all the counsel for the respondent would like to contest the aforenoted application, he may put in his response by the said date, re-notify on
28 May 20.
that day. We hear the appeal also.
Item 8 and 9.
Order the case on 18th.
May I please your lordships? Due to some personal difficulties, the engaged counsel couldn't appear today, lordship. The matter may be adjourned for the day, lordship.
Who is leading you in this matter?
Mr. M. Sharma.
What happened is what have we done on the last date?
So our order should be 18th order. Please give it a principal.
नाम तो इसके खिलाफ है।
When you spoke from the difference, we have changed them. This case goes for response file करने ये paragraph में है। इसलिए हम लोग पार्टी तो ट्रांसफर का इफेक्ट हो गया। We have not paid in. So
with respect to the advisory. All right.
Only with regard to item 9, that has to be argued, Lord,
Ah,
because
next
one, he has already joined.
He's already.
Right, but he has gone from zonal office to Gauhati.
Yes, sir.
What difference does it make?
But with regard to the manner.
You can always do your, union work,
But with regard to the manner, he was.
advisory, all right, but otherwise also.
Otherwise,
you-
the transfer, we are never been objected. He has served in 7 districts in 5.
But why do we question the advisory? Why do we decide it?
The advisory, the manner in which it was issued is not.
Doesn't
not as
matter,
per
it's
the-
only an advisory.
No, but there is a sentence in the advisory at last which says it has to be implemented.
No, that is different, but advisory is not something which is under our scrutiny.
Lordship-
It's for internal consumption. Why do we exercise our jurisdiction under Article 226 to question that?
Lordship, as long as it is done in the policy which is promulgated
No,
by.
unless it adversely affects somebody, then we question it. Otherwise not. An advisory is not it doesn't have any statutory force. Why should we apply our minds to it? Get ready in that matter. Then we say that it is not for us to decide whether the advisory is correct or not. You decide your rule of housekeeping.
Lordship, but has to be within the limits of the policy which is.
Correct. So,
Right.
but would it be amenable to writ jurisdiction? That's my question. You'll have to
Yeah.
answer that.
Yes, Lordship, will come,
Prima facie, we don't think we need to question the advisory.
Lordship.
Suppose as Chief Justice of the state, I issue an advisory that persons who have remained in registry for 3 years ought to be transferred. Who would question it? I mean, it could be questioned by the judges of this court. It could be to the dislike of the persons who are in registry. But can it be decided by any court of law that this advisory is incorrect?
Lordship, as long as the advisory.
Anyway, we have
Lordship,
told you our mind.
Fix a date, Lordship, we can fix it.
We will, a prayer for adjournment has been made on behalf of the respondent on the ground of indisposition of Mr. M. Sharma, learned advocate, who has to address this court. Let this matter come up for consideration on, give a date in June. If you're ready, if she would have been ready, we would have decided it today.
Lordship.
We don't tinker with the advisories of the
Lordship,
bank. That's meant for internal consumption. It doesn't have the force of law.
It does affect the persons who are,
Maybe then you come
we
as
came back in appeal, Lordship, that is the person who is
बड़ा
affected.
मुश्किल है. Then if you're not questioning your transfer from zonal office to
We
Gauhati,
did, Lordship, in the appeal, that's
you
why.
may have done that, but
Yes,
today you are not doing it. So why do we get into that
Lordship has
controversy?
fixed the writ petition.
We
on
may
the-
have. Can't we change our
Yeah,
opinion?
no, Lordship, not in that.
Chalo, yes.
15
On
June.
the next day, we will decide.
Yes,
I mean,
Lordship.
maybe we'll be thinking on a different plane on the next
Yes,
day.
Lordship.
Let's see.
Much
Obliged.
obliged.
Item 11.
May I please, my lords?
Yes.
As in item 11, the government had to come back with the number of vacancy present, my lord, as per the last two orders that my lord would have. This is the case where, my lord, I was well in merit. Yet, my lord, my degree came late from the university. And I had written to the government, to which they have till date not taken a decision. So, my lord, on the last two
Yes,
occasions.
Mr. Kotner.
Well, the total post was advertised is 8230, out of which, my lord, 1659 posts are vacant, my lord.
No. He's asking for something else. Did we say that?
Yes.
Indeed, my lords, indeed.
110, yeah, the orders are 110 to 50.
Just.
Try your last one.
Well, तुम कोर्ट में लिखा था.
हाँ, ये हो गया सब. Only this was.
What is your instruction now? Now that we get to know what we have decided, Mr. Kalra's arguments have been rejected in its entirety on principles of law.
Yes, my lord.
But then, since they have lost out on age, and you have some posts vacant, would you consider them?
That, my lord, there's,
Otherwise, we have formally decided this petition.
yes, in fact, my lord, page 187 of the writ appeal, my lord, similar case has already been dismissed my
Why
lord.
don't you say specifically that it is not possible for us?
Yes,
You
my
will
lord.
say
That,
sorry
that,
to
that
Mr.
is,
Kal.
that is my instruction, my lord.
You do one thing.
Yes.
You put it on record. We take it. We will be left with no option but to accept it. But they will have some opportunity of challenging it.
My lord.
They are not inclined to relax that. And it is only for the purposes of, not, entertaining any petition where the necessary certificates come late or came late, that this midway change was made. That midway change is justifiable. That is what we have held in our last order. So we have asked from them whether they could entertain such petition in view of the fact that so many posts are still vacant. But then they take a call, and in fact, they have taken a call that would merge with another recruitment process which they would begin. In that case, we can't force them, we can't issue a mandamus to them. We should not rather. But then you can try your luck. So let that statement be on record. Then we decide and we accept it, and then you.
Just give me 1 minute, my lord. Just
One
give me
thing, my lord,
60
there is
seconds.
no
my lord.
fresh advertisement, my lord.
Yeah,
Subsequent
there
posts, my
is.
lord.
Yeah, that is what I wanted to come to. There has already been an advertisement. The post have been advertised, and the next recruitment is over. There is no fresh recruitment. So, my lords. So therefore, my lords, the vacant post will remain unfilled. In fact, what my lords had on the last day when the matter.
No, Mr. Kalra, that is not the way it works. That is not the normal system. That is not the normal way in which the cookie crumbles.
I
All the vacant posts are merged in the next recruitment process, and that is also over.
Well,
Now, third
fortunate-
process would begin.
well,
You
fortunate-
have lost out on age, but we can't help it because you came 20 months later.
My lords, just give me, my lords, let me just clear this prejudice that is there, my lords have against me.
There is no
For-
prejudice. We were trying to help you out. Why do you say
Listen, my
prejudice?
lord, no, for today,
Mr.
for
Kalra,
today,
why do you say prejudice?
for today, for
We have
today,
overstretched our powers.
indeed, for this 20 months late, I must clarify, my lord, I had made a representation as
That we have already noted it down. Please.
so therefore, my lords, what I am saying is this: had the case been, because this is the second time they had to take instructions, twice they have taken instructions and come back and said that they are vacant positions.
They have taken instructions and they say it is not possible. And
Lord,
it is not possible for us to issue any mandamus now.
my lord, it is most humbly, I would, with greatest respect, I would submit, my lord. Even today, the instruction they have brought in, with greatest respect, my lord, kindly consider. They say there are about 1,600 posts vacant, and it is not a case that I am low on merit. Please appreciate this fact, my lord. Plus, my lord, as per the rules, I had to apply 7 days in advance to get a relaxation. I had applied. Is it their case that they have decided the representation, my lord?
Mr. Kalra, why don't you understand? You appear to be a seasoned counsel. Therefore, we would record based on our observations in the last page of the last order.
Lord.
We would record their submission. You have all the opportunity.
Indeed, my lord. I mean, my lord, if the issue can
challenge
be
it before a higher court, but we, as a bench of this court, we don't think that any mandamus can be issued in this matter.
I understand, my lord. So therefore, can I just suggest this, my lord? Let them file an official reply, my lord. Let them disclose.
What else did I say?
Let them disclose that there are 1,600
What
posts.
else did I say?
Very well, my lord. Very well. We'll have it on that.
Mr. Khatniar, put
Yes.
it on record.
Yes.
See, there is no hide and seek. We know it very clearly.
Indeed.
That in this matter, we cannot issue a mandamus for whatever reason for the delay. And then there is no perversity in the order of the learned single judge. We have dealt with that in our interim order. I mean,
In
the order
past.
dated 24th of February 2026. Perhaps the order was dictated in your presence. You have heard it. So we don't think you have a case, but for you to have a passage.
I understand, my lord. We are truly grateful.
We are asking him to put it on record. We will say that in view of this statement, we are not able to pass any order. Let you try.
Very well.
Why do we stop you? Why do we stop you here?
Very well. But let him put an affidavit and let it be served 3
Mr.
days.
Khatniar,
Yes.
by tomorrow. File this affidavit tomorrow. We conclude
Yes,
it day after tomorrow. Why delay? Let him go before the
Yes, my lord. My lord will fix it on Monday. I will file it by tomorrow, my lord.
as prayed for by Mr. Khatniar. Let this appeal be listed on. Give a date on Monday.
27 April.
Open lordship.
Sir,
I'm so
a copy.
great-
You have a local counsel here.
Yes, my lord. He's present.
Serve a copy to him.
Yes, my lord.
I'm so grateful for the.
And no further arguments on that day. With that statement, we will conclude it.
Certainly, my lord. Just one request, if I can make. If he serves me, I'll just put a 1-page reply to that. That's all. I won't argue.
We'll accept it. We'll accept
well.
it on board.
I won't argue, my lords. I commit to that.
No,
I'm so
really?
grateful for the indulgence, my lord. I'm so grateful for the indulgence. Deeply grateful.
Item 12 to 17 and item 40 of the supplementary list.
I am appearing in item number 60. I will assist your lordship by giving 4 judgments. One of the judgment belongs to your lordship. They got all India.
Did I commit a mistake there?
No, there your lordship was saying that because they wanted that, no, all employees.
No, you have to remind us what is the matter. We don't remember. We don't have that robotic memory as Mr. Das.
Yes.
Mr. Das, you may be having such memories.
No, your
but
lordship has more. That's why we.
You have to tell us what is this matter about, why all these matters have been tied together, what is the issue. Now it is for final hearing.
We are challenging the provision of law by which, my lord, the 6 scheduled areas people, persons were prohibited from competing with the process of appointment of land record assistant.
No. You have put it differently. Now there can't be any embargo on 6 scheduled people. What I remember of the earlier argument is that these persons who are before this court,
Yeah.
they were nominated by the Bodoland Territorial Council for being trained in Assam for record for that RCC record examination. Correct. So there, because they hail from such area where a different syllabus was tailor made for them. So they say in this regular process, they would not be
So
eligible.
on residential.
That's all right. That's the argument. You don't broaden the scope by saying that any person from 6th schedule area will be prohibited from doing this.
They have been
Any person nominated by
Yes,
BTC
nominated
Ah.
by nomination.
for that
passed the
particular
training.
for that particular kind of course.
Yeah. For that nomination, my lord, they have passed the training, so they are now eligible for the purpose of competing with the.
Correct. So
So-
let us see let us see the judgments.
So it facts your lordship knows much better than.
No,
us.
broadly, vaguely, we remember
No,
this.
Nor is known to your lordship.
19 people voted.
That if your lordship wants to go through this provision of law.
But before that, Mr. Das, let me just go through our earlier order of 19.2.
Court judgment with it.
Already passed it. When they were training only when he was appointed as a working agent. This नहीं अगर इनको जैसे इनका 18 months इसमें कुछ Yes, give us. Give us the judgments.
Well, lordship allows me to go through the provision of law which came into force, my lord.
We just saw that, but please,
That's all.
please, you begin your way. You begin your way. Yes.
Look at page 48, my lord.
Which petition, Mr.?
Item number 16. My short submission is, my lord, there cannot be any discrimination on the ground of residence. That is my submission.
Page 48.
48.
Yes.
This is the law they brought in, and this is for one-time measure only.
This is the notification, this is the amendment in the service rules of 2023.
Yes, Rule 5, 1A. They
Okay.
brought in. 1A is, my lord, notwithstanding anything contained in these rules or any other rules or regulations, the candidate, except candidates nominated by the territorial and autonomous council areas of Assam, who have undergone the 6-month recorder's certificate class course training at the Assam Survey and so training center and have been declared proficient in the mandated examination by an official results declared by the Director of Land Records and Surveys, etc., Assam, in both survey and settlement zones. So they have excluded the persons belonging to those who have nominated, those who have passed. Earlier, my lord, on the basis of the same rule, 750 persons were appointed where persons from the.
No, Mr. Das, that's all right. You have a
That is
ground
the
there.
facts.
You have a ground there, but you miss out on something very, I mean, something in the interregnum is required to be remembered. Now, initially the rules were that those who passed this 6 months course
Oh,
would automatically get appointed subject to the vacancy. They came out with a rule in 1991 saying that no, sorry, 2021. They came out with a rule, they said that no, this training would be necessary only after you are appointed with the government. Correct. So in order to avoid that, they came with 2023 amendment in 1A. They said that as a one-time measure, those who have not been appointed but have passed that course of 6 months, barring those who were nominated by BTC, they shall be considered. So in that case also your argument subsists. Your argument with exclusion on the ground of residence succeeds. I mean, it subsists, not succeeds. The Mr. Borpujari will be required to answer whether nominated persons from BTC underwent a different kind of course, then perhaps yes, the distinction could be made. But if it is the same course,
same course.
then perhaps it will be difficult for him to sustain.
course and
For one, and this is, and that also it's a one-time measure. That also is a one-time measure.
One-time measure.
So after this advertisement, a person has first to obtain an appointment, get appointed to the government service, and then he can go for the records. This is only one-time measure.
Reverse.
That is not question. The question, the challenge here is to your exclusion because you have been nominated by BTC. Maybe for their state, whatever they would be doing, but they can't do it, no? Yes.
The 6th schedule area and seals of
We followed that.
Now page 51, the advertisement.
Yeah. Which you will obtain through.
Page 51, advertisement, serial 2, my lord. Candidate must have passed.
Very sweetie chunks. Yes.
Serial 2, candidates must have passed recorder certificate class course training from Assam Survey and Settlement Training Center, Dekingaon, Gauhati 40, as per advertisement for so and so. Examination issued by the Office of the Directorial and except 6th schedule area.
Exactly.
6th schedule areas we have from NC.
So what would be the rationale, Mr.?
So now, four judgment may I just.
Yes.
The judgment will be. First judgment, your lordship, this is a Andhra Pradesh case where they were saying, my lord, they have changed the provision of law, my lord. They have amended and they have made it 15 years mandatory residential qualifications for the purpose of competing in the process of appointment. This is number 1969 1 Supreme Court 1 SCC, judgment by Justice Hidayatullah, and very succinctly written, and it says because of Article 16(3), my lord, there cannot be discrimination on the ground of residence. Particularly if you goes to paragraph 2 and 3. Ultimately, para 5(6). Only Parliament can make law as regard residence because of Article 35A.
Which paragraph are you referring to?
In paragraph, my lord, I have paragraph 2, your lordship will kindly see, that is the law. May I read this?
Yes.
Paragraph 2. The first is, my lord, your lordship, that first paragraph is also important. The petitioners are person employed in the ministerial services of the Andhra Pradesh government. All of them were working in various offices located in the cities of Hyderabad and Secunderabad. January 69, leaders of all political parties in the legislature of Andhra Pradesh state appear to have met and reached the decision that to implement what are they called Telangana safeguards, the following measures should be taken. All non-domicile persons who have been appointed either directly by promotions or by transfer to posts reserved under the Andhra Pradesh Public Employment for Employment Rules 1959 for domiciles of Telangana region will be immediately relieved from service. The posts so rendered vacant will be filled by qualified candidates possessing domicile qualifications, and in cases where such candidates are not available, the post shall be left unfulfilled till qualified domicile candidates become available. Action on the above lines will be taken. Accordingly, my lord, paragraph 2, somewhat after about 6 lines, the action was based upon section 3 of the Public Employment Recruitment and as to Residence Act 1957, which was an act of parliament made in pursuance of clause 3 of article 16(3) of the Constitution. The act is this, my lord, section 3, power to make rules in respect of certain classes of public employment in certain areas. The central government may by notifications in the official gazette make rules prescribing in regard to the appointment to any proviso, any requirement as to residents within the Telangana area or the state union territory as the case may be. Now, Rule 3, your lordship will kindly see, below it is mentioned, Rule 3, your lordship has seen, the rule is, he has been continuously residing within the said area for a period of not less than 15 years. So if one is a continuous residence of 15 years, they only can compete in the process of employment under the provision of the Act. So this was put to challenge. And paragraph 4, your lordship will kindly say, and Article 16 has been discussed. And paragraph 5, it says, enables Parliament to make the law in special case as regard residents in view of Article 35A. Five and 6.
Yeah, 1 second. All right, yes.
So paragraph 12, it was held to be unconstitutional. It was quashed. And next, my lord, your lordship goes to flag B, which was a bonus marks given on the basis of the residence. That was also interfered.
This is Kailash Chand Sharma.
Very good.
Yes,
Bonus marks.
yes, yes.
Was given, it was held to be bad.
Then this 1995 judgment, this is weightage to the particular language as medium.
5 months extra. Hopefully, we also learn the same. And next is, my lord, your lordship judgment, where, my lord,
Employment exchange.
employment exchange. Your lordship opened it now, everybody is entitled to participate in the process. So in view of this, my lord, there cannot be, my lord, discrimination only on the ground of residence. You belong to BTC, you belong to other 6 scheduled areas. It cannot be done. And it's in one time, everybody must have an opportunity to, since we have the qualification.
Yes.
Not maybe place to take up item number 12 where we have filed our affidavit, my lord. And that affidavit I have circulated amongst all the councils. We'll be relying on that affidavit.
Yes.
Paragraph 9, my lord. Running
Of
page,
your counter affidavit, we will get it at page?
page, my lord, running page number 75, paragraph 9.
76 should work, 70. Paragraph 9 at page 75, yes.
Yes, my lord. There we have set out, my lord, the factual matrix, my lord. What
Read
has
that,
led
read,
to-
read it
Yes,
with
yes,
us.
Yes, my lord, that with regard to so and so, that the respondent authorities being mindful of the situation of the candidates who had successfully completed RCC training from non-council batches, that is the batches conducted by district administrations from across the general area of Assam since 2008, introduced the Assam Land Record Subordinate Service Amendment Rules 2025 notified on so and so by inserting sub-rule 1A in Rule 5 of the principal rules. It is stated that the amendment is a one-time remedial measure confined to those candidates who have already cleared the RCC examination with proficiency certificates issued by the Director of Land Records and Surveys, etc. Assam. As per data available with the respondents, approximately 1,518 candidates were declared proficient in non-council batches of training at ASTCC since 2008, of whom 751 had already been appointed as land records assistants, leaving approximately 767 candidates yet to be absorbed. It is for the purpose of this group that the one-time measure is designed to give benefit to them. It is further stated that the exclusion of candidates nominated by the territorial and autonomous council areas from sub-rule 1A is deliberate, lawful, and based on sound constitutional and administrative principles as demonstrated herein below. Thereafter, my lord, we have set for the grounds, my lord, at paragraph 10. First and foremost ground, my lord, is the revenue is a transferred subject. Now, under the 6th schedule of the Constitution, para 3 to the 6th schedule of the Constitution, this, my lord, 6 schedule areas have the full autonomy to enact laws pertaining to, my lord, land revenue. Meaning there are, my lord, these posts, my lord, to which pertains to land records assistance, these were earlier designated as LAT mandals. Now they are, my lord, redesignated as land record assistants. They have their own, my lord, parameters, my lord. They have their own peculiar factual matrices, my lord. They have their own peculiar social system, my lord, out there in those councils. So therefore,
That's all right,
yes.
Mr. Bhattacharya. This training was conducted under the Assam
Assam Survey
Assam
Settlement-
Institute.
Yes, it is a centralized institute and it is a very technical qualification.
Correct, correct.
Yes.
So this cannot be a ground. Revenue is a transferred subject. This cannot be a ground. You could only say that under the 6th schedule, only local persons are taken into service. So therefore, they would
Yes,
eat
that
away on the post reserve.
Yes.
So only because it is a transferred subject cannot be any ground whatsoever.
Therefore, my lord, ground number B, my lord, at paragraph 10 at page 75, I will be so grateful, my lord. Page 76, my lord, ground number B at paragraph 10. Separate mode of recruitment in autonomous council areas. The autonomous councils have their own mechanisms for appointment of revenue officials within their territorial jurisdiction. Accordingly, the petitioners being residents and having been nominated by the BTC area, for the example of this matter, my lord, have ample and separate avenues for employment as revenue officials within the BTC area through the autonomous council's own establishment.
And next time the revenue department, the revenue subject would be handled in a different way in a 6th schedule area. They will say that we will only take locals. So where do they go? Not necessarily. All of these petitioners are not locals of 6th schedule. They reside there.
Yes.
Just that. But why do you exclude them? I don't think it's a correct way to interpret.
My lord, the primary endeavor, what appears to me is, my lord, that, my lord, there is a backlog, my lord, earlier.
Now, just a minute.
Yes.
when you say that it is meant for 767 candidates,
Yes.
you refer to them as well,
Yes.
because they have also passed.
Yes.
How come can you exclude them?
If we allow this, Mr. Vapujari, no post, there will be two selections. BTC residents will not be able to participate in any transport subject in state of Assam.
That of course, that is subject to further debate. But question is that they would get opportunity there also. You never know.
Yes.
You
Because
never know, because they might come up with some rule like Sikkim where they would say that only the locals.
already local.
And Mr. Ken Chaudhary is smiling. He would say that yes, only locals because of the constitution.
Because, my lord, in one of the tag matters, my lord, BTC have filed affidavit where they have stated, my lord, they are contemplating to enact rules, my lord, for appointment.
I don't think it's a justifiable ground.
Because
It militates against Article 16 of the Constitution of India, clearly.
my lord, earlier, prior to 20.
If these are the only reasons, they are absolutely unconvincing. We were under the impression initially, therefore we say that one should not bank on the memory. One should read the file every time that the matter is to be argued. We were of the impression that they have undergone a different kind of course. Of course,
So it is a
then you
centralized-
have a justification of saying that this course, like another thing which I saw here as a special measure, only 18 months B.Ed degree. There could be some distinction. But here it is the same course conducted by an institute located in Assam, and you acknowledge them as pass out people. Correct.
Certification is same.
So then you advertise and you exclude them. How can you do that? Only on the basis of their having been nominated. Nomination is one part. They undergo a course, the same course with the same contours of the syllabus. How can you stop them? Number one. Number two, revenue being a transferred subject does not does not make them, does not give them any benefit. There, because of the sixth schedule protection, they would be entitled to do it only for the local people, which perhaps would meet the constitutional muster. But not for them. You don't say that they are local people, they would not understand. What kind of logic is this? Absolutely warped.
They have their permanent residence there. So they are nominated, they were nominated earlier by those, my lord, six scheduled councils. my lord.
How does it make a difference?
Now, my lord,
Are they only local tribals?
no, my lord, not
No, then-
necessarily
then-
tribal. They are residents of those six scheduled.
And even if they were, they would have double privilege of being totally that those posts reserved for them if at all they come out with a law like that. And in general category is open category.
It is an open category.
Ah.
Now, in order to avoid that, my lord.
If that is the only ground which you have stated in page 10, then I don't think you have a case.
Two further
Then I think
grounds,
Mr. Das has a clean
my lord.
sweep.
For half a minute, my lord, two further grounds, my lord, two further, with all respect, my lord. Number one, my lord, prior to 2023, when the rules came to be promulgated in the year 2023, prior to 2023, RCC training was a prerequisite. One has to have the technical qualification, then seek for appointment.
Look at this,
And
Mr.
yes,
Why do we get into that
No,
argument?
my lord, and
Mr. Borpujari,
and
kindly
the
hear this.
qualification was
Just-
unmatriculate. Yes.
Just a minute, just a minute. We will show you our own order where we have dictated this.
I think number 12 means.
This is item number 12.
No.
Sudeep, you are referring to which? Item number 12 ka file do.
Sudeep, Patta,
Sudeep.
Yes.
May come to order dated 19th of February 2026.
Yes, my lord, I have it.
Do you have a copy of that?
Yes, my lord, yes.
Come to page 4.
Yes, my lord.
The 1991 rules, however, have undergone change in the year 2023, which provide that a person is to be imparted the RCC training only after his or her being appointed as a revenue officer.
Absolutely.
So this came out in 2023.
Yes.
This way, all these pass outs would be completely excluded because they have first to get into this training, would not see their entry in the government service.
Absolutely.
They have to pass a different examination to get into government service
Yes.
in the revenue department and
Yes.
then undergo this course. So this was prior to 2023.
My lord.
1991 rules automatic. I mean, that was the only way in which you could have got in the service.
My lord.
Now, in the year 2025, the government of Assam came with an amendment to the Assam Land Rules of 2023, thereby inserting 1A in Rule 5. And pursuant to this, you have made this arrangement. And what you have said in your counter affidavit, that it is for the purposes of accommodating those 767 people, which includes these petitioners.
Yes.
Which includes these petitioners. How can you, by an advertisement, exclude them? Purpose is this only. And therefore, it was made a one-time exercise.
One time.
Now, no more thereafter.
No more.
They will have to. So, how can you exclude them? By what logic? By what principle?
Well, one aspect of.
Can you do that as a state?
One aspect of, well, subject to lordship examination. Well,
We are only reasoning out. See,
absolutely.
had this been in the state of Bihar or state of UP or Maharashtra, there would have been not, we would not have spent even more than 2 minutes in striking it down. The care is to be taken in a state like Assam, which is a artificial construct with so many, tribal areas with their own laws, with their own things. Therefore, we are taking time so that we don't go wrong. Had it been in other state where there is no such reservation of any kind, it would have taken not more than 2 minutes to strike down such an advertisement straight away as unconstitutional. No, here, there is no such protection.
Yes, that I have to fairly submit.
We are careful in
Yes.
seeing this, that we don't trespass into something which is very special to the state of Assam
No.
or the 6 scheduled areas here.
Those candidates who were left out, they were not graduates. The 2023 rules made it mandated, my lord, that mandatory that
Correct,
one has to be a graduate.
Why?
Those were not, so they will have no opportunity of employment. at
That
any
is
future-
another limb of argument which Mr. Das has not addressed.
That is, I
That
think
could
Mr.
have been-
Sarania is there.
Yes.
In that case.
No, that could have been another argument.
It
The
is
question
being
is, you
spent on-
can't exclude them. When you're doing it for people from Assam, you can't exclude them because it is your institute which has imparted them training. You want to sort of completely obliterate that.
I can understand, well, there cannot be a.
So therefore, we
sub-classification.
we quash that part of the advertisement, appoint them also.
will
They
be
come
able-
under 767.
They will be able to participate in the selection process.
Correct.
Yes.
Don't stop them there. All the petitions are allowed.
Some petitions
Last
can-
date is 30th one.
Hmm?
Last date. the
No, we
30th.
pass an order today.
And 17 is concerned.
Hmm.
There is a bit difference.
Yes.
That writ appeal is there. What happened is that in 13 and 15, my lords, the lordship had passed one order in the month of August. It's asking that which rule BTAD is following with respect to RCC class scores, 92 or 2023. Subsequently, they come with the additional affidavit saying that BTC has not adopted any rules of 2023.
But why do we get into that?
No,
You are concerned with this advertisement.
But
no?
we are, item number 13 and 15, we are covered by your lordship, this judgment. Will be covered,
Mr. Burgoyne,
my lord.
you are aggrieved by your exclusion by virtue of this advertisement.
Yes.
So why do we get into other arguments? Why it is
No,
different?
this was subsequent development. That's why I'm telling that in prayer is different.
If this covers your case,
It will cover.
why do you want to have?
No,
other
it will
grounds?
cover mine. It will cover. My lord, as far as writ appeal is there, my lord, that has to be dealing, my lord.
That has to be?
It has to be dealing.
Which
Writ
item?
appeal.
13, or 14, 13, 14, because like,
209.
13, 14.
कहाँ पर है ये?
Number 14.
Item number 14, what have we done in this?
My lord, what happened is that,
No, what do you want to do in
my lord,
this?
in this matter, we have challenged the order of the land as single judge. It has to be delisted from this present series.
All right.
Well,
Like here?
Item number.
No, we will pass judgment only in 12 and 13.
No, my lord.
12, 13, 15, 17.
13 is
12,
also
13,
different, my
15.
lord. 13 is also different.
17 and 40.
12, 16 and 17.
Uh,
Same child. Prayer is same.
12, 16.
17.
12, 16, 17 and 40, 40, my lord, 40.
नहीं नहीं तो
40.
13 भी आ जाएगा ना?
Yes.
13.
13 and 15, we were aggrieved by the exclusion. We anticipated that which your lordship has
So
recorded.
therefore 12, 13, 15, 16, 17.
Yes.
Only 14 goes.
14 remains. 14 is,
14 you are not withdrawing. 14 will be decided later.
14 will have to be decided by law.
My lord, item
That's
number
the
13 is
14,
also
sir.
different. Different, my lord. 13 to 23 matter. 13, how?
Exclusion.
Except 14, yes.
25 would challenge for an 8 to 25 would.
14 you argue, who is arguing 14?
Pardon, my lord?
Who is arguing item number 14?
Item number 14, I am arguing, my lord.
What do you want to,
What lordship-
we'll dispose it of today.
Your
in
lordship,
separate order.
With item number 40 is also same, 40.
Yes,
40 has
yes,
been
yes.
recorded, 40. But clarify it so far relating to
if I
item
may-
number 13.
If I may
My lord,
clarify,
the
my lord.
Item number 30.
Advertisement 2020.
Your lordship will kindly see the paper book of 7408.
जो भी करेगा, उससे मतलब नहीं है.
If I may clarify, my lord.
Most
when
of
we
it.
challenge for-
You, who appears in item number 13?
I am appearing.
You merge your, you say that your prayer is that
It will cover up with this. It will cover up.
Doesn't matter. I will decide it wholly in a holistic manner on constitutional principles. Correct. So 14 you argue.
My lord,
Chalo 14 do.
14 to.
Item 14 is, my lord, primarily to be registered by the BTC authorities. Yeah, yes.
Your lordship, what happened is that in item number 14,
We'll hear it on some other date.
my lord.
Lordship.
My lord, because if your
Yeah, just a minute. And what is the subject matter of challenge here?
subject matter of challenge is that we have been recommended by the BTC, deputed by the BTC
Same as them.
as them.
Hmm.
But instead of us taking us 219 candidates, they provided the second list, 150 candidates.
This is-
Lordship,
And they are saying,
We will unnecessarily, the facts will
Will com-
dovetail into the other.
complicate.
Let it come some other day. देखिए, let this case, item number 14, पूरा लिख लो, let this case be listed under the appropriate heading on,
in the month of May, my lord.
in the month of?
May.
In the month of May. Sometimes in late May. 14 को हटाओ इसमें से.
Mr. Sikdar's clients, they were already appointed.
They have already, not appointed, they have been given, they are undergoing the training of the 6 months.
these three petitioners were recommended,
Yeah,
your lordship.
don't enter into this. हटाइए. We will be deciding 12, 13, 15, 16, 17 and 14.
My lord.
40, not 14.
14.
40.
40.
Lordship, they were recommended by an authority which he is not entitled under the law.
Let us,
They have-
let us,
Lordship,
We will hear that today. Unnecessarily we'll be introducing. Thank you, Mr. Das. You made a very pithy argument which appealed to us straight away. उसको अभी देना मेरे पास. बहुत बढ़िया से लिखा दूंगा. ठीक है ना? कल देंगे. आज अलाउ कर दिया है. कल देंगे.
When is the
30. वो देंगे. Judgment will come tomorrow. आज तक लिखा है.
लिख के देखना.
Item 18.
The word must yet. Yes. 1 second. Excellent. Again, what's the bit? giving you an opportunity of hearing. No, CAT did not give you an opportunity.
Yes, my
We are giving you an opportunity, but where is the difficulty in the order?
Here, my lord, CAT decided the matter on the basis of the Honorable High Court order, my lord. That is in-
Honorable High Court had only passed an order that decide,
Yes, my lord.
don't delay,
Yes, my
because
lord.
he will lose out on appointment in a different public sector
Yes, my
undertaking.
lord. So.
Just
according-
that.
Yes.
Otherwise, High Court would not have had any jurisdiction in the
Yes, ma'am.
matter. So you decided.
Yes,
That
ma'am.
was struck down by CAT, by
Yes.
tribunal.
Yes, my lord.
And tribunal's reason is very correct. Now, which master circular are you referring to?
My lord, that is in page number
इसको लिखा दो।
Page number 164, my lord.
154.
164.
164.
Yes, my lord.
Where is the book? What about it? नहीं कुछ नहीं बदमाश है। 164. Yes.
Yes, my lord. This is the circular, my lord. Kindly come to point number 2, my lord.
Hmm?
Point number 2, my lord. Forwarding of application to the central government department, public sector, and the semi-government autonomous bodies. Railway employee, whether permanent or temporary, may give for opportunity to apply for post in the government department, public undertaking, autonomous body wholly on substantive the financial control by the central and the state government. However, the general manager had the state general manager department any withhold the application if they feel that in the public interest it is not possible to release the railway servant concerned for the post outside the railway.
This
No.
master circular is itself, but you can't keep anybody captive. This master circular is itself, it doesn't pass the muster of constitutionality.
There are 2.2 next page.
Yes.
Hmm.
It clarifies this thing.
Yes, what is it?
While it is
Read
not-
2.2. Read 2.2.
Why?
Every day we have to release our judicial officers. They want to go for deputation. They want to quit the job and go for other. How do we stop them?
Well,
Yes.
2.2. While it is not feasible to define the public interest, the authorities should interpret the term strictly and subject to the condition that forwarding the application should be in the rule rather than
Exception.
and decision should be taken an appropriate level.
Hmm.
In taking the decision to withhold the application, the authority has to balance the interest of the state against the necessity of the causing hardship to the individual.
Hmm.
This discretion should be applied with the utmost objectivity.
Not mechanically.
Not mechanically. My lord, here, not mechanically. While it is not the feasible to lay down the specific exhausted guidelines for withholding the application, application in public interest, some of them can be listed illustratively as follows. Here, my lord, we did not do it mechanically, my lord. Kindly see, my lord, there is also a bond, my lord. At the time of, that is in page number 177, my lord. At the time of appointment, he signed one bond also, my lord.
तुम कहाँ लिखा है? अब you are showing something जो हमने लिखा था.
और जो alia round में आया था हमारे सामने, that is at page 157. First one.
177, my lord. And condition are in page number.
Just a minute.
Yes, sir.
ये तो दूसरा केस है. ये तो दूसरा केस है. No, ये तो बिहार का सर्विस नहीं ना है. ये तो पब्लिक सेक्टर undertaking. This is a different case. Why have you annexed this order, Mr. This order passed? This is with respect to a different person, no?
Yes, my lord, that is the part of the way, my lord. Which-
This is a page 156. You have annexed our order.
Yes, 156, my lord, divine person. On the basis of that, Honorable Cat, my lord, passed the order, my lord. This is the High Court, this Lordship's order, my lord, 156. my lord.
Acha, this was the order with respect to the petitioner.
Not with respect to the petitioner, my lord. From other, that is the part of the hearing. This is the part of the OA, my lord.
Yes.
Part of the OA.
नहीं ये क्यों लगाया है? ये तो this is something
They
different.
have annexed in OA before the CAT, my lord.
Union of India versus Jagdev Kumar, ये कौन है? इसको क्या है? Why
This person also approached High Court earlier.
Yes, no. They
Railway,
didn't.
Railway has approached High Court in a similar matter, challenging the order of the.
in a similar matter, not in the same matter?
Not the same, not.
So therefore, we were confused. What is this?
No, my lord, that is a part of the OA.
There, my lord, lordship was pleased to dismiss the petition only, again, immediately on the date, next day, they have released. This on attain time.
So therefore, this order
Basically
was
covered.
no, this order was taken help of by the tribunal in deciding your
Exact.
case.
Yes.
Exact.
We dismiss it now.
Okay.
Take down. We are dismissing this petition. There is nothing here.
My lord,
Anything else that you want to say?
well, I think, I want to say one thing in page number 1, so they have signed one bond also, my lord.
Nothing. You can't hold them captive. This is, you are an employer agreed, but then this is not the way. You can't. Where is the master circular? Just give us the page number.
Page number 170. Sorry, 164. 164.
बहुत लगेगा.
We want, my lord, and 2.2 A, my lord. We are relying on 2.2 A, master circular.
Yeah.
The officer concerned is engaged in important time-bound project and the work.
We have heard Miss A. Gayan, learned CGC, है ना?
Yes, my lord.
Learned CGC for the petitioner / Union of India and 4 others, and Mr. H.K. Das for the sole respondent. The challenge in the present petition is to the order dated 12th of March 2026, passed by the Central Administrative Tribunal Gauhati bench in OA number 040/00043/2026, whereby the prayer made on behalf of the respondent for acceptance of his technical resignation was allowed, and the petitioner was directed grant the technical resignation in favor of the respondent as prayed by him in his application dated 29/1/2026 within a period of 10 days from the date of receipt of the certified copy of the order of the tribunal, with the condition that the respondent would not have any lien over the current post he had been occupying after joining as grade 7 under Oil India Authorities, Dulijan. Stop. The facts lie in a very short compass. The respondent serving on a technical post at Dibrugarh Mechanical Workshop with the railways had applied for a grade 7 executive post in Oil India Limited, Dulijan, sometimes in the year 2025. Fortunately, the respondent Fortunately for him, the respondent cleared the selection process, but faced repeated hurdles in joining such high job because of the railway department in not granting a no objection certificate or permission to join the new job. The stand of the railways in not coming forth with the acceptance of technical resignation or granting permission to the respondent to join his new job was acute staff shortage. And the respondent being the sole civil supervisor handling important time-bound infrastructure project at the workshop. So, an indemnity bond that the respondent had signed at the time of joining as an apprentice, which required him to serve the railways for at least 5 years. This was beyond 5 years, no?
No, my lord, in fact, in the railway rules, there is a provision.
No.
I'm sorry.
I'm asking you for a fact.
I'm sorry.
It was within those 5 years.
Within those 5 years. But
What
the
a-
railway has a rule that that bond will be transferred to the next organization. It's there. And other persons were, my lord, released.
It
with
is
the
there in the,
condition
it,
that
it is
bond-
there in the master circular.
No, there is a IREM, there is a provision. I'll just place, my lord.
Place that.
Aside.
No, but the tribunal should have given an opportunity to the railways. On that ground, do we remand it back? But then you will
No,
lose out on your job.
It will cost me my job.
I mean, that will cost you, but then the tribunal should have been careful, no? You must have forced that order,
No.
showing urgency,
Tribunal-
as you do in the High Court.
That I am extremely sorry.
Yes.
1410. There is a provision. What happens?
Refund of cost of training and enforcement of bond money in respect of railway employees. So you will have you refunded?
No, there is no requirement of refund.
Yes,
Bond
yes,
gets
refund.
transferred, my lord, in between middle, my lord. The
What?
railway administration with whom the employee has executed the original.
Where are you
bond,
reading from?
My lord, line about 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. 14 line, my lord.
1410.
1410, yes, my lord.
Hmm.
Page 166. In between middle, the railway administration, the line starts, my lord.
Hmm.
The railway administration with whom the employee has executed the original bond may at the time of forwarding his application for another post may write to the department organization under whom the employee intends to take up another appointment, intimating them about the bond obligation of the individual and clarifying that in the event of his selection for the new post, his release will be subject to the condition that the new department organization obtains from him a fresh bond, binding him to serve them for the balance original bond period. And in case he fails to serve the new department organization or leaves it before completion of the original bond period for a job where exemption from bond obligation is not available, the proportionate bond money should be realized from the individual and refunded to the railway administration. The original bond that will get transferred to the new.
But then here, see, no, Mr. Das, don't talk like that. Argue, which makes sense. This is with respect to, you're seeking appointment at the same level. You are seeking appointment and you've got an appointment at executive grade 7. There, you will not be required to file any indemnity bond.
No.
At that stage, you don't file any indemnity bond. In that case, it has to be refunded.
May I just explain? It's not within the railway.
No.
I'll
Please,
just explain. No, Lordship will kindly have a look.
you read from the beginning, 1410, refund.
Yes. Look,
Read
they have already released person who got employment in Bihar with that condition that he will serve the new organization in Bihar, state government.
At what level?
No.
My lord,
What has been done for a person who sought an appointment in the state of Bihar is none of the concern of this court or yours.
my lord,
It should not be your concern.
technical
Now read this.
yes, my lord.
Read this 1410 in its entirety. This
Yes.
does not apply to you. What applies to you is that within 5 years of your indemnity bond, you have been given permission. We allow that. We ratify the order of the tribunal, but then you refund. No, indemnity bond is still surviving for another 5 years. Look at this. Read. Don't try and conflate two issues.
No, no, my lord, never.
This is with respect. You don't intend to do that deliberately, but then the way you're interpreting it would amount to conflating two issues.
Yes.
Look at this. I don't think we have gone wrong in reading 1410.
No. Yes, I'll just explain, you know.
First you read and then explain.
Yes.
That is self-explanatory.
Refund of cost of training and enforcement of bond money in respect of railway employees who secured employment elsewhere on the basis of their.
Now,
duty
let
for-
us see your before this, we'll see your indemnity bond. Where is that indemnity bond?
The indemnity bond they have annexed,
177.
that your lordship will find.
Page number 177, my lord. And clause in 179.
आप तो ये बहस ही नहीं की थी. This only caught our attention. You had not argued.
Sorry.
177.
Shall repay on demand the government the whole cost of training of pay and other amounts excluding travelling and running allowances drawn by a trainee. Clear. Now read this 1410.
Yes, my lord.
कहाँ है? 1410 वाला कौन पेज था? 1410 यहाँ पर है.
Non-gazetted railway employees who have not.
Is separately there, 1410.
हाँ, यहाँ. ये तो हो गया. हाँ. Yes. And this is Indian Railway Establishment Manual.
IREM volume 1, my lord.
And even if this were not there, now we would go by your indemnity bond.
Yes, my lord.
We'll
My
go
lord,
by
this-
your indemnity bond.
this
Now
indemnity bond
we will leave that option open for the railways to get the money refunded from you. You're leaving the job, no?
Lord, that's true. My lord, it's my duty to clarify the position, my lord. Lordship will have a look, page 140.
First you read 1410.
Yes, my lord. Non-gazetted railway employees who have not received training at the railway expenses in a specific avocation but only have been given an induction course to make them suitable to the working needs of the railway may be exempted from refunding the cost of
Do
training.
you fall in this category?
No, my lord.
Do you fall in that inducted employee category, or were you given the training? Because the indemnity bond says you were given the training.
No, I'm not disputing. Training is there.
We're only looking at it from all stages.
Correct.
Now, so therefore you don't come under this exemption
Yes.
clause. Then thereafter,
Induction course to make them suitable to the working needs of the railway may be exempted from refunding the cost of training in the event of their selection to the other post under the central or state government or in public sector undertaking, stroke autonomous bodies, wholly or substantially owned, finance, controlled by the central government or a state government. However, a fresh bond should be taken from such employees
no,
to
this,
ensure.
their department,
that-
this is under their.
So the bond gets transferred to the next organization. Whether-
Mr. Das,
I'm
you are not in that non-gazetted railway employee category.
Non-gazetted,
You're, अभी आप कहाँ जा रहे हैं?
grade 7, my lord.
Grade 7. Grade 7, the number, as the number
It's not
increases, that's,
gazetted. It's not gazetted, my lord.
it's an executed. If at all, but we will give them that if it is be transferred, but then that amount shall be refunded, whichever is overdue.
My lord,
In
basically,
terms of 1410, we will leave that option to them.
no, before that, lordship will kindly appreciate my thing, my lord. My lord, there are two provisions. One is refunding the money. Second is that the bond gets transferred to the next organization. It doesn't specify because lordship, one aspect,
I don't
I
know
can
whether,
ask for, my lord, I can ask for technical resignation if the post wherein I am going, it's a higher post only. I can ask for technical resignation because that provision is there. So the post wherein I will be going,
we are not impressed by this argument.
my lord,
However, a fresh bond should be taken from such employees to ensure that they serve the new employer for the balance of the original
Or
bond period.
period of
That's for the
bond.
5. The railway administration with whom the employee has executed the original bond may at the time of forwarding of his application,
Yes.
if not possible before his release for another post, may write to the department under
Yes.
whom the employee intends to take up another appointment, intimating them about the bond obligation of the
Yes.
individual and clarifying that in the event of his selection to the new post, his release will be subject to the condition
Yes.
that the new department organization obtains from him a fresh bond binding him to serve them for the balance of the original bond period, and in case he fails to serve the new department organization or leaves it before the completion of the original bond period for a job where exemption from bond obligation is not available, the proportionate bond money should be
That-
realized from individual and refunded.
That-
So have you informed that? Have you informed this to the Oil India Limited
Yes.
that you have executed an indemnity
procedure-
bond?
The procedure followed is that
Hmm.
when the railway will release me,
Hmm.
they will insert a paragraph. Page 140, my lord will kindly have. 140
Of?
of the writ petition. It is the railway will intimate the other department while releasing me down below, my lord.
Hmm.
They will insert this paragraph. There are many examples. His release is subject to the
That's all right.
condition.
That's all right.
So this condition.
Even if you had not shown this, we would have said that it will be governed by, it will depend upon them, it will be governed by the Indian Railway Establishment Manual.
Yes, my lord. I'll have to be governed by 1410.
But then if the post on which you're going, if that does not require any indemnity bond, then you return the money.
No, I am bound to serve there, the bond period. Otherwise, as per 1410, I'll have to refund. The question of refund comes as per 1410 when I will not complete the 5 years, including the railway service in oil mill. Then only the question of refund of the bond money will come.
Whether they require bond or not, these bond will continue for the rest.
Page 140, then 141. Already,
इसको अगर वहाँ indemnity bond की जरूरत नहीं होगी at grade 7, then he has to refund the amount. He has to refund the amount.
suppose I have completed 2 years here, then I'll have to complete 3 years there, total 5 years. If I fail to complete 3 years there and I again venture for another appointment,
देखिए
then I'll have to refund. That is the condition.
आप देखिए इनकी indemnity bond
Page 141 also
shall
has
repay on
another
demand
order.
the government whole cost of training or pay of other employees. That is his undertaking. It will not turn up there.
As per law.
As per law.
As per prevailing law.
Page 141 also.
Since they have not raised this issue, we'll say that it will be open for the railways to go by the railway establishment rules so far as refund of money is concerned.
Milord,
there is-
instead of that, Milord, it will be suggested, instead of that, Milord, both the parties will go by the provisions of 141.
Why both the parties?
Or the railway.
No, we have to take care of the employer also. We are taking your care, we will take care of the employer also.
Milord, the
Return the
rules-
money and be happy, go to Oil India.
If
You
the
see,
rule says.
We can also say that forget about the rules. This indemnity bond is beyond the rules. Then,
Indemnity bond has come by virtue of the
Rules.
rule 1410.
so let it be decided by your employer.
Why should you interpret that?
So normally.
आप वहाँ नौकरी भी नहीं करेंगे, आप शॉर्टेज ऑफ स्टाफ को भी इग्नोर करेंगे, आप चले भी जाएंगे ऑयल इंडिया में और उसके बाद you want everything to be done in your favor.
Lordship is correct. But what the railway is following, I have demonstrated before your lordship.
So we are not
140
suggesting railway what to do. We are
It'll
saying
be-
that
it'll
we
be
will go as per
open for them.
Open for them.
140 and 141, already they have.
According to the rules, we will not even specify the rules. According to the rules,
Yes.
they can, if they find out some rules, you see, these Department of Posts, Department of Railways, Department of Telecommunication, they have so many circulars, it's a compendium. They can find out any circular anytime which will require you to pay back the money. They can have the
I can
circulars.
at least assure you, Milord, I have done that much of research in this matter.
Uh.
There is no circular left in technical resignation matter
And
or bond
you
that I have
can't,
overlooked. Milord.
you can't be so sure, Mr. Das.
Milord, I am sure.
You can't be.
Milord, I am sure.
Anyway, but we will not rely on your assurance that you have checked up everything. Like, what did I say? We forgot what we were dictating. नहीं उसके पहले पढ़ो क्या लिखा था Handling important time-bound infrastructure project at the workshop. And he having an indemnity bond at the time of joining as an apprentice, which required him to serve the railways for at least 5 years. 5 years. Full stop. This delay in grant of permission to the respondent to his filing a writ petition before the Gauhati High Court. A direction was issued to the railways decide his NOC application expeditiously. Only thereafter that a detailed / speaking order was passed on 4th of February 2026, rejecting the NOC on the strength of the Railway Board's Master Circular number 30, dated 15th of July 1991. The railways thereafter the respondent thereafter, the tribunal sought a direction against the railways to grant him technical resignation, to accept his technical resignation. The tribunal allowed the application and, as noted above, directed the railways to accept the technical resignation within 10 days. Condition, but with the caveat that the respondent would have no lien on his present post after joining the All India Limited. One of the contentions raised by Ms. Gayam on behalf of the petitioner is that the tribunal passed the order impugned without giving the railways an opportunity to file a written statement or argue its case. Stop. Because of this, it has been contended that the Railway Board guidelines were completely ignored while passing the order. Stop. There was the railways, the petitioner had been facing acute shortage of staff, especially in time-bound projects. First up. The Master Circular provides that any railway employee, whether permanent or temporary, would be given 4 opportunities to apply for posts in government department / public sector undertaking / autonomous bodies substantially financed and controlled by central or state governments. However, the head of the department / general managers would be at liberty to withhold such applications if it is found that in the interest of if it is found that in public interest it would not be feasible to release the railway servant concerned for a post outside the railways. next paragraph, the circular further clarifies that while it may not be feasible to define public interest, but the authorities would be well advised to interpret the term strictly and subject to the condition that forwarding of applications should be the rule rather than the exception, and the decision should be taken at appropriate level. The interest of the employer and employee both, according to the circular, are required to be taken care of and balanced. The discretion has to be applied with utmost objectivity and not mechanically. Some of the circumstances under which such consent could be withheld are when the employee concerned is engaged on important time-bound project and the work would be seriously distorted if he is relieved, or the railway servant applies for a post which is equivalent in status and work. The railway servant is facing departmental proceeding / court prosecution or is under suspension. While perusing the impugned order of the tribunal, we are of the view that the tribunal ought to have given ample opportunity to the railways to represent its case. Nonetheless, the central government standing council was heard on behalf of the railways, who had conversed that there was an acute shortage of staff in the works cadre in the division where the respondent had been working, and therefore his being relieved would not be in public interest. In public interest. Looking at the facts of this case, looking at the facts of the case of the respondent, even if it is assumed that there is acute staff shortage, the statement made on behalf of the railways that there is 60% vacancy in the junior engineer cadre, it would not have been fair for the railways in not relieving the employee / respondent, especially when he was moving to a higher post in a Government of India undertaking, namely Oil India Limited. The post on which the respondent was selected was a higher post with a different work mandate, and the respondent had not been facing any departmental proceeding, court prosecution, or was ever under suspension. He definitely but was under the terms of the indemnity bond, which he had furnished of serving the railways for next 5 years, and in case of his exit, he would return the cost of training and other refundable expenses. The time period of the bond still subsists. Next line. The time period of the bond still subsists. Full stop. Considering the case of the employee, considering the case of the respondent and the employer, bracket petitioner, that the tribunal did not actually go wrong in directing for the immediate grant of permission to the respondent to join his new higher post in Oil India Limited. However, while ratifying the order passed by the tribunal, which has been impugned in the present petition, observe that the respondent shall be bound by the indemnity bond which he has furnished, and any demand for refund of the cost of training or of enforcement of the bond money would be subject to the Indian Railway Establishment Manual and other rules in that regard, which could be exacted by the railways if deemed necessary. With the aforenoted observation, the writ petition is dismissed. We have been as less abrasive as we could be. We have said that it will be as per the rules, but they would be ready to, they would have the liberty to exact it from you.
No problem. Only one, or his service in the other organization. That
And
is
as per
also-
the rules, we have said.
As per the.
So therefore, we will not
They should not
specify.
think that they can, immediately go for this.
Challenge it.
No. Enough for this boy, my lord. He has been succumbed to so much of litigation.
And
It has been a
please don't
simple
annex
issue.
such different orders in different context by this court in your writ petition. You can do it before the tribunal, not here.
Yes.
We were under the impression that it was this court which had granted, which had asked for the speaking order. No, we got confused. No, we don't see the name of the parties. We see. Yes.
Item 19.
Yes, Mr. Chandra.
I think about a year back, my learned friend was asked to obtain the instruction. About a year back. Every time, sometimes my learned friend is not present.
Possible, we have filed a counter. Because
Counter file করে আমার কপি দিছেন?
It prior to this order.
Would have been made either. Never challenged that judgment
Yes.
of the learned single judge. That was highly challengeable. Because this date cannot be fixed, Mr. Chaudhary, if I remember correctly, I had made that observation.
In fact, in your last order, Milord, your lordship should kindly have an order dated 24/3/26. Notwithstanding everything, Milord, please have a look at last but one para. Be that as it may, considering the fact that with one stroke of pen, the appellants along with others were promoted to the higher post of assistant engineer on the strength of Rule 11(4)(c) of the 2015 rules, there could not be any distinction between some of them and the appellants to be given the notional promotion from that particular date and denying the same benefit to the appellant. Mr. Godbuzari, learned standing counsel, 6 time. So since my learned friend was not there,
Mr. Kumar.
so Mr. Godbuzari appeared.
Should be in the year 2015.
Hmm?
The two of the requisitioners preferred.
Repeat those facts, no?
Yes.
Everything is there in the order which has just been referred to.
Yes.
Did you challenge that order of the learned single judge of granting retrospective notional promotion to them? It could have been very challengeable. They could see the rules. Rules cannot be interpreted like this, that the moment you acquire a degree of AMIE, you would be given you would be appointed to the promoted to the higher post. There cannot be anything like that. If the rules are there, that must be changed, because unless the vacancy is notified, your acquiring the eligibility by acquiring a certificate of engineering called AMIE popularly all over the country will not see you promoted. Correct. So there, but you never questioned it. It was granted from the day when the judgment was passed. Later, the other set of people, the notional benefits were given from a date which was 6 months post the judgment. They want this. Now, in review, they actually chose a wrong forum. But then many a times, even if you bark against a wrong tree, you get the relief. Here he did not get the relief. Now he has come before us. Now, we have two options with us. Yes. Mr. Chaudhary will acknowledge. Either we rejected that this cannot be done in review. And since we have challenged the review, file a fresh petition. But instead of doing that, we will state that for the reason that we cannot justify this. With our stroke of pen, we cannot justify this. The order is highly challengeable. But because they have not challenged it, Mr. Kumar, you have chosen to sit tight over the matter. And now you are not applying parity. Can you do that? I don't think you have followed what we are trying to tell you.
Otherwise also, retrospective promotion cannot be given.
Who is talking?
Cannot be given.
Who is saying this?
This is the law.
You have capitulated. You have done that. And that has not been questioned. Can you make this argument now? The only argument which you can make is that your lordships would ask them to approach the court afresh, not in review. That's the only thing that you can ask for, which we don't think is advisable.
Yes. No, lordship, they have filed a review petition that has already been disposed of.
The better option for you is to concede. Ask Mr. Port Pujari, he understood it. Ask him to concede that you will do it, we will close the petition. Otherwise, you will face trouble. You should have advised the estate not to accept that order.
In that event, today, 10 days time may be given to
Can?
take 10 days time.
But why?
Instruction.
So
Whether I speak- Yes, when I speak with-
Mr. Borpujari, Learned Standing Counsel Finance, seeks some time to take instructions in the matter and get back to this court by the next date. It is coming after 3 months, 1 month.
Your Lordship, is the matter relates to consignal.
We can grant you time for 1 week. Take instructions, concede, there is no
Yes.
payout. We will otherwise direct. We are telling you. We'll otherwise direct for it. Because you are at fault, no? Otherwise, we would have said that that has not been challenged. Why do we disentitle them of the benefits which has come to them? हम लोग कौन सा केस में डिसाइड किया है केस में where Mr. Chaudhary, you were not there? You were there.
Similar rule,
Regarding parity, my lord.
not parity, acquisition of qualification and
हाँ, हाँ.
promotion.
वो कहाँ था judgment हमने
That-
कहा?
Similar
Yes, yes, 11(4)(c) only.
So we can't go beyond that. कहाँ है 1143 वाला लिखा
They have not ready with, it is there. I'll get it on next date. my lord.
But then why that was a case which came to us, we decided. Here there is a decision and there is no challenge. Now can we look at it from another? See, Mr. Borpujari and Mr. Kumar, you have to look at it.
Yes, sir.
At least post. I mean, in hindsight also you must gain that wisdom of challenging it. मुश्किल है हम तो कहेंगे कि since there is no challenge, you cannot possibly make any distinction. Where is that judgment? Give it to me. वो 11(4)(c) का किसके नाम से था? Mr. Chaudhary was on one side and Mr. Kumar, some senior advocate,
Slightly.
BD Kaur was there.
Mr. B.D. Kumar. We
Yes,
did-
BD court.
And Mr. Nayak was also there.
It was a very well contested, case.
Biswajit Das.
निकलो अभी देखो.
Biswajit Das.
इसको हम भेज देंगे, इसको हम नहीं करेंगे. No, we can't pass an order after having delivered a judgment in Vishwajit Das. We can't possibly do this. इसको भेज देते हैं कहीं और. We don't want to divest you of the benefits of litigation, but we can't possibly legally justify this. The best way out, you see, we are interested in granting relief, not snatching away the reliefs. तो इसको कहीं और भेज देते हैं. If you want to argue, we'll send it somewhere else.
But I think Biswajit Das' point was slightly
देखें,
different.
well, let us see.
There, I think it was in the context of, my lord, whether occurrence of a vacancy.
Same thing. No?
Same thing.
That is the principle that we are espousing.
Principle is same, but here where nobody
Rule
is
is same.
questioning that our intrusion.
No, there should not be.
Question is, my lord, intrusion is
See,
nobody
there are
questioning.
people who would immediately take out the 2 judgments of this court and say that in one case he decides like this and in the other he says something else. And Mr. Chaudhary, in that case you lost.
Huh.
In this case you will be winning.
Oh, my lord.
Can we do that?
Originally in that case.
And
was
the,
also
and the
claim
fault
of-
lies not with you, not with the bench, but with Mr. Kumar. He has not challenged that judgment of single judge.
Original judgment.
इसको ऐसा करते हैं अभी छोड़.
उसका भी, that original
You
judgment.
have been promoted. No, you only want 6 months.
Yes,
इसको जाने
notional
दीजिए.
benefit.
इसको we will admit for hearing. Otherwise, we will have to take back everything from everybody. And we don't want to do that.
Then I will leave it to lords.
I leave, see, if I don't give that privilege to you, then all those who have got that, even those persons by virtue of that judgment, that will have to be reviewed. We don't want to do that. Let it remain dormant for some time. We will decide it later.
Okay.
As jointly prayed for. In the meantime, you take instructions.
Yes, sir.
As jointly prayed for. Had it not been my judgment authored by me, I could have taken a call here, but it'll be difficult for me. Because here, with the passage of time, on grounds of parity, you deserve, but on principle, you don't.
In fact, our case is only on parity. I brought 3 judgments on parity offset. And let it be decided
Original
after
thing is
some time.
doubtful, no? Original order is doubtful.
Acquisition. उस केस में भी तो they wanted automatic काम कराए, उनको करके direct.
अच्छा, ऐसा many times such situation would come where we would pass an order which would be different from the earlier order. Unless one is reminded of that. Who reminded us? My brother reminded me.
It's not humanly possible also. And then once it has come to a lordship notice, leave it to a lordship.
As you're right, as jointly prayed for, but we don't want to divest people of the benefits that they have taken. People come here for benefit, not for damage. As prayed for, as jointly prayed for. Let's this matter on some date in July. उस समय देखेंगे. But in the meantime, both of you take instructions.
21-7.
Oblige.
Item 21.
20 क्या हो गया? फादर जो है तो क्या उसमें लिखना होने जा ये फिर आगे में राइट टू एजुकेशन लगेगा अरे बाप रे
Possibly a lot of.
एक मिनट देखिए नहीं सर तो था 11 फोर्सी नहीं था ईयर और कैलेंडर ईयर और सब
But we go with this.
11C
11C, acquisition of qualification, then well, this husband originally ये था कि they will like immediately after acquisition they will get a promotion. Vacancy या कोई बात नहीं कुछ नहीं promotion. Then it came directly with them promotion. Challenge क्या था the other side.
इसको उसी फाइल में रख देना Yes, Mr. Mazumdar.
My lord, possibly in terms of your lordship's directions, the state government has issued directions. In the meantime, my lord, Honorable Supreme Court has passed an order to frame rules. So we have started the process of drafting the rules also for compliance specifically of section 12(1).
Yes, Ms. Varma.
And not one, my lord, several, to all the authorities, my lord, director, inspector, to all your directions and directions.
Lordship, that will subsequently happen, but what about the PI lordship? They have not opened the portal for the unaided.
Why have you not opened the
But it's
portal?
open. Now I think it's
No,
done.
the schools have not registered the,
My lord, lordship is,
in the
lordship is
school
TV.
websites,
My lord,
do
lordship
not
is
find the
TV instructions
vacancy.
they have mentioned. About the portal also it's mentioned.
Lordship, I do not have a copy of the instructions served to the court, Lordship.
Why don't you give a copy to her? She's so passionately fighting this case. I mean, you should have given it. She's not doing it for herself. It's in public interest. Give it to her. Give it to her. We hear you tomorrow.
Lordship, tomorrow I am not in town, Lordship.
Now,
Next
this is
week.
for urgency. Now, whichever date you may say.
Lordship, I'm extremely sorry. Tomorrow there's a medical emergency. I'm traveling.
That's
out.
right. So, we have said tomorrow only to satisfy you that we want this matter to be decided.
Lordship,
Immediately after
week.
CB.
Next week.
Next week,
Serve a
Lordship.
copy.
My lord.
Mr.
Mazumdar.
Mr. Dilip Mazumdar, Learned Additional Advocate General, Assam, submits that the last of the affidavits filed on behalf of the state, that a copy of the last of the affidavits filed on behalf of the state shall be served upon.
Not agree with this instruction.
You put it on record, Mr. Mazumdar.
Better, my lord. I'll file an affidavit annexing all this.
Mr. Dilip Mazumdar, Learned Additional Advocate General, Assam, seeks some time to please record the instructions given by the state Department of School Education, which to a large extent would redress the grievance of the petitioner who is espousing the cause of students. A copy of such instruction shall be served on the counsel for the petitioner, in advance. Let this matter come up for consideration on, we
30th
keep it
Lordship.
sometimes in May, on May,
My
10, 11, 12. Today is Thursday, no? We keep it on 14th,
Lordship,
14th of May,
before that, because the session has already started, Lordship.
12th of May, 5th of May.
30th, I should be back, Lordship. 30th of this month, Lordship.
This month. 5th of May.
Let it,
5th of May.
Fourth is a Monday, Lordship may have it on.
Fourth is a holiday, Lordship, fifth is.
4th is a holiday.
Here, yeah.
Not holiday.
4th is not a holiday.
Third is a holiday.
Lordship.
3rd is Sunday, not
Sunday,
holiday.
Third is Sunday, man.
Oh, that is Sunday.
4th or 5th?
Fourth,
Fifth.
here it shows a holiday in this calendar, fifth, we can,
Are you looking at the calendar of May?
26, May.
I-
Lordship.
From there, the official calendar of Gauhati High Court. 5th of May, to be on the safer side if they have committed any mistake. 5th of,
Mistake, because fourth year shows a red.
all right, 5th of May.
That should like Lordship. Lordship, can I have a copy of the instructions to?
We've said that.
Definitely, man. We'll
We have said that he is putting on affidavit. Copy will be served upon him.
Item 24.
उसमें तो AG उपयोग करेगा.
Lordship, this matter is led by the learned advocate general, Lordship. Today is out of station, Lordship. I bring for some recommendation.
Yes, Mr. Neil.
This is perhaps the third time on the.
We have actually requested the state, no, state, in fact, in the first instance, we requested the state. When would he be available?
Tomorrow or else next week, Lordship. Next week.
Give a short date.
Fine.
If you're not available, we can give you a longer date.
Can it be Monday?
Coming Monday.
Lordship,
I don't
Monday, it'll be difficult, Lordship.
I don't think so.
Any day after.
In that case, one of the,
Thursday, Friday.
on 6th.
As prayed for on behalf of the state, on account of absence of the learned advocate general who is to address this court in this matter. The case is adjourned to 6th of May.
Let's say maybe I'll verify the date from my senior Lordship and get back to the court master with the consent of the other side, Lordship.
What?
Whether my senior will be available on.
You'll have to
6th or
mention tomorrow. Court master cannot give you a date once we have given you a date.
Lordship, 6th, I don't know whether he'll be available on 6th or not,
So
Lordship.
it is,
Lordship,
the
give me
date
5
has been,
minutes,
the
Lordship.
date has been given with a caveat that on 6th you inform him beforehand that it is not possible. We'll fix it for another date, a shorter date.
Lordship.
But then you can't do it without us, acceding to the request. Yes, once we have given the date.
Lordship.
Item 26.
Ayurvedic doctors.
Met with the lordships. Matter relates to pay parity of Ayurvedic doctor and the medical allopathic doctors. My lord, learned single judge.
Again, there is some difficulty. They are seeking adjournment.
This matter is led by Mr. B. Gogoi, Lordship. He's on legs in court number 10, Lordship. I prayed that a matter may pass over for the timing, Lordship.
And tomorrow. Tomorrow or next week. See, they say that you have been put in the same slab, but your contention is that
No,
increments
there-
you're not getting.
No. There is a judgment of this honorable court. Its order has attained finality.
Okay.
According to that judgment, we should be paid at par with the MO.
Correct.
Now, learned single judge, my lord, relying upon PA Bhatt and all, has come to a conclusion that we are not performing the same nature.
No, वो तो नहीं होगा ना.
The
The
question,
argument would be different.
yes,
If at all Mr. Gogoi has to make an argument, that will be different.
yes.
They will say that this pay parity in that judgment which says that allopathy and homeopathy should be treated alike so far as payment is concerned, that is with respect to basic salary, increment whether it would include.
No, that doesn't
No, it doesn't say, but that is the only argument that he can make.
Now what had happened, towards implementation of the order of the learned single judge, they have come up with a notification. The juniors are getting higher pay, we are getting less.
So Mr. Gogoi will come when? Next week करते हैं? Want to tell Mr. Chaudhary if the other side lawyer is here.
Lordships kept the matter for final disposal actually.
No, we have kept it for final disposal, but we can't because we have a matter at 2 o'clock in chambers, which is very, very contentious where a father is fighting his 2 sons.
Okay.
A father wants his 2 sons to be evicted.
Okay.
And 2 sons are absolutely jobless, moneyless, penniless. And father is more than 85 years of age. He is not amenable to reason. So we have got, see, acting on the concept of mediation for the nation.
Can I? Calcify?
Tomorrow, we can hear it tomorrow.
Tomorrow.
Tomorrow. Tomorrow ask Mr. Gogoi to be here.
Yeah.
पासवर्ड के लिए यहाँ क्या लिखते हैं? लिखिए, let this matter come up for consideration on tomorrow. तो ये लोग करी, they will not be able to, you know, the registry has to be.
Or in that case, my lord,
Monday.
let it come up on 14th, my lord.
14th of May.
Yes.
Tomorrow,
whether it will be listed or not, that is also.
it is very difficult, no? Here, supplementary list.
First week, my lord, I have some difficulty. Otherwise, I have the prayed for first week.
14th of May. That's a good day. लिखिए, Mr. Ken Chaudhary, London senior advocate, is present. For the appellant is present. However, a prayer for adjournment has been made. However, a prayer for passover has been made on behalf of the state, as Mr. B. Gogoi, learned advocate, who has to address this court, is in another court. The request, seeing the heavy board today, such a request cannot be acceded to. Let this matter come up for consideration on 14th of
Yes.
May.
Item 29.
Just perhaps recall that this is the PI where we were seeking compensation for prisoners in the matter. Those who have been incarcerated and those who have died in prison. My learned friend Mr. Gogoi appears in the matter and he was.
Rules have been framed.
Yes.
You wanted a clarification with
Clarification
respect to
without-
persons who
yes.
died before the rules.
Off the
Let
record
Mr.
today-
Gogoi come on 14th.
14th, Your Lordships?
लिखिए, as same order जिसमें किया हो अभी वही करना.
Much of it.
Ask Mr. Gogoi to be here, leaving other
He was
courts, he should be.
During the morning hours, he was telling me that the government is not willing to.
We'll see what is to be done. Let it.
Perhaps orders might be necessary from Your Lordships.
All right.
I'm deeply obliged.
क्या इनका भी 14 को कर दो उसी दिन. हाँ? चलो रखो ना, तो नहीं होगा देखेंगे. इसको खत्म करेंगे.
Item 30 and 31.
ब्रह्मपुत्र बोर्ड में फिर बहुत लंबे.
I am appearing in item number 31 for the appellant.
Yes.
My humble prayer is that we are having electricity issue in Delhi. So my Wi-Fi is erratic. And this matter was being physically heard. If your lordships is kind enough to accommodate us on 6th of May, we can come physically and assist your lordships with the hearing of the case.
That would be wonderful. I don't think other advocates will have any
Lord,
problem.
6th, I have some difficulty.
6th, one of the senior advocates appearing for one of the parties would be in some difficulty.
Next week.
You can choose another date.
19.
Uh,
Can it be on 19 if this?
Monday would be 6th
19th of May.
19th of May.
19th of May.
19th of May. Just a minute, please. Just a minute. 19th of May is all right.
Yes.
Jointly prayed for, but with the caveat that since you are mentioning it on the ground of lack of electricity and your Wi-Fi having been disturbed, that day you must come in person and argue.
Would your lordships be kind enough to have it on 22nd of May?
Yes, 22nd of May.
Yes.
Why not?
Grateful. I'll definitely come physically.
Just a minute. 22nd, there is
22nd I
some
have
difficulty. 25th of May then.
Very well. 25th of May,
Chlega.
in fact, 25th of May is again a problem because I have a matter
21 to
fixed.
27, I will not be there, my lord.
So keep it on 29th of May.
Yes.
That is the best date.
Yes.
29th
Very well.
of May.
Very well. Grateful.
As jointly
Grateful.
prayed for, list
Grateful.
both the
Grateful.
list both the cases on 29th of May. All right.
Deeply grateful.
Item 35. Sorry.
This is that Brahmaputra board matter.
Yes.
Yes, in fact, this is with regard to an OM of March 2000, whereby the Government of India, Ministry of Expenditure, that is the nodal ministry, had taken a decision that the pension would not be payable under the OM of 87 unless there is a specific decision. Because of the fiscal policies, that decision was taken. And the issue is covered by a 3-judge bench of the Honorable Supreme Court in TM Sampath's case, in which I happen to be one of the counsels, which was cited before the learned single judge, but which has not been at all adverted to.
All right, we'll see it on that date.
29th minutes.
29th.
Grateful minutes, grateful.
Item 35.
Here, my lord. What has happened is they have imposed a restriction that 100% of the tea that dust tea.
53.
Your lordship is aware there are 4 different grades of tea: whole leaf, broken, fannings, and dust. So they have identified only dust tea for 100% sale through auction. So virtually they have tied our hands, my lord. 19-1 tea completely gone. So that is what is under challenge.
1953.
Page 51 is the order.
Now this tea marketing control amendment order 2024 brings in paragraph 21. Correct?
Your lordship will find it at
The original control order of 2003. I mean, do we have the control order of 2024, the amendment order?
yes, well, it is annexed. That is what is imputed. Page 51.
Subsection 3 and 5, section 30 of Tea Act.
Clause 2 is important.
Just a minute, we are looking at something different. Power to control price and distribution of tea or waste. The central government may by general special order prohibit the disposal of tea waste except in such circumstances and under such conditions. Mini tea factory?
I'm sorry, what?
Mini tea factory. Mini tea factory.
It is the small grow.
That we understand, but who decides it? Does it depend on the area of the tea garden or something else?
Production.
Or the turnover or production?
Depends on
Because
the product.
those are exempt. Those are exempt from this amendment.
Yes.
You don't fall in that category. The difficulty is this. Now, therefore, we looked at the Tea Act.
Yes.
Now, under section 30,
Yes.
subclause 3 and 5, they have the powers to do so. Wholly.
No, that is one of my contentions before your lordship. If your lordship kindly comes to 30, section 30, they have.
Give us a copy of the Tea Act.
On the last occasion, we had already.
Yes, yes, all right, we have.
Power has been exercised under subsection 3 and subsection 5. 3 says, central government may by general or special order prohibit the disposal of tea or tea waste except we are not concerned. B is what can be perhaps direct in any person growing, manufacturing or holding in stock tea or tea waste to sell the whole or a part of such tea or tea waste so grown or manufactured during any specified period, or to sell the whole or a part of the tea or tea waste so held in stock to such person or class of persons, and in such circumstances as may be specified. It is to whom they can, is something they can regulate, but through is something which is.
No, that is restricting the scope. The manner of sale, to whom such persons, class of persons, and in such circumstances
Yeah.
may be specified. No, you can't put such fetters. Then
Yes.
subsection 3C.
There are other grounds also.
Read C.
Yes. Regulate by licenses, permits, or otherwise the production, storage, transportation, or distribution of tea or teas. Here they are.
Sale nahi hai.
Sale is
In-person-
not. So nearest thing possible is B one. And that also says that to whom, and there is a logic behind it. But through is something, how can they, it is putting fetters, it would amount to a unreasonable restriction.
It's okay, but the constitutionality of this provision for such other. Hmm? Oh,
And the other thing, Malad,
वही है। नहीं, power दिया हुआ है. It is ever declared that the expedient public in the union should take control of the industry. बस तो ठीक है, उससे नहीं है, but take control means इनका बस है ना, total waste होता है. They don't take care of it. And 5 is the power of superintendence. And what grounds Mr. R.K.D. Chaudhary has
there
given?
are, before that one, may I, if your lordship comes back to page 51 for a moment, there are 2-3 other stark discrimination. Your lordship is aware there are 4 different
We are
grades.
not aware of anything. You have to make us aware.
Well, in that case, when it comes to tea, there are 4 different grades.
Hmm.
One is known as whole leaf, the other one is known as broken, the third is fannings, and the fourth is dust.
Hmm.
They have, without any logic, they have simply identified, if your lordship comes back to page 51, your lordship will find, it is only the dust tea grade, and the imposition is 100%.
But
And your lordship will find all the South Indian states are excluded. It is only.
no, but the difficulty is that under subclause 3 of section 30 of the Tea Act, everything is controlled. That
But that
amendment
argument,
is- No, it
argument I'll
talks
come
of
to.
prohibit the disposal of tea or tea waste. So they don't talk of any other grade. They can do anything from anywhere.
But even if the power is available, they cannot discriminate irrationally.
No,
There is a discrimination twofold.
question of discrimination comes only when anyway, we'll see. So
That is one of the points. And the other 2 contentions, I am looking at the clock, Manoj, I am being as brief as possible.
no, we will have it after the chamber case is over. We'll come back again to hear you. कौन है बेटे रे? वो तो यहाँ सुनेंगे ना. Thereafter. There's
Is the other matter carries on. Your
No,
lordship can have it next week.
no. See, it is always good to have judges from outside. Otherwise, there are many things which are known to the local judges. I did not know something which we will not be free till about 3:30. There are 2 matters. One is a pushback matter where a council from Delhi is addressing us. and the other is a matter between father and two sons.
And four, there is a separate.
And 4, my brother has to hold another bench. So I think this case goes on some other date. But then on that day, you give us some
Otherwise,
case
it
laws.
should not take more than 15-20 minutes.
It's in a very slender argument,
Yes.
but then we need case laws and all.
Yes. In fact, my lord, the other thing I would be arguing is 19(1)(g), and that can only be done.
91G is a general argument. We don't care for
When
it.
they want to bring in a reasonable restriction, they can, but it has to be by way of a
Mr. Apul
legislation.
Sharma, you are in this case. Okay.
The lordship may fix it on 14th.
Yes.
14th of May.
लिखिए, 14th, there are many matters on 14th.
Or else, my lord, 12th.
No, keep it on 21st. 14th.
Subject to your lordship's convenience.
List this matter on 14th, list this case on 14th of May. But it is on your request, otherwise today we will hear it. So we say, as prayed for on behalf of the petitioner, as prayed by
Not
Mr.
put it on me, man.
Then please wait, 3:30 we will resume again.
Oh, but I'll leave it to your lord.
As jointly prayed for. Let's list these two matters. कौन सा matter है ये? Item number?
35.
List this case on 14th of May.
But may I also take the liberty, my lord, very next matter is also where my friend appears. I am appearing for ONGC.
For feature of gratuity.
Yes.
That will depend on his concession.
No, he is the one who's, he is the one who's seeking.
He is the one who is seeking. क्या नाम है आपका? Mr. Hazarika. A prayer for adjournment has been made by Mr. R.P. Hazarika, learned advocate for the appellant. Let this case come up for consideration on 2nd of May.
My lord, 22nd, I have a bit of what difficult. In that case, my lord, can it be first week of June? That last portion of May.
2nd of June.
Yes, 2nd.
ये पुशबैक हो गया पुशबैक और चेंबर में यहीं पकड़ेंगे नहीं चेंबर में करेंगे नजदीक से सुनेंगे बुला लेना उसको वो आ गया है मैन ऑन व्हील चेयर एनीवे विल सी
Item 37.
Yes, Mr. Hegde is appearing in this matter. Yes.
Please, my lords, I'm sorry.
That matter, we were stuck up in our chambers for one
Please,
one
my
case
lords, I believe so.
where a father and his two sons are fighting. Anyway, so today the Advocate General is missing from this court since morning.
I believe so, my lords. And given the timing today, my lords, let me be candid with your lordships. My argument will rely a lot on a judgment of the Calcutta High Court in a matter called Bodhu Sheikh. I had already put it up in my written submissions. Bodhu Sheikh's matter has been adjourned from time to time in the Supreme Court, which has not yet issued notice. It is actually listed tomorrow.
Okay. So what we do is that we keep it for the next week. In that case, you can always, we will await that decision in Supreme Court also.
No, let me be further candid, my lords. I do expect developments in Bodhu Sheikh and similar matters after the 4th of May.
So let's keep it after. Let us keep it after.
Let me be. Please, ma'am.
You have been more candid than what was necessary, but then nonetheless, let us adjourn this matter.
It may well clear a lot of concepts.
Why don't we keep it on 4th of June?
If in the month of May, my lords, I am here. Thereafter, I am subject to my family, my lords.
All right, so you want a date in May?
In May,
which
in
date?
May, maybe the 10th, around the 10th, 15th, in any of that.
10th would be 10th is a holiday, that is a Sunday.
Please, my
So
lords.
from 11 to
I-
15, we have fixed many matters.
Yes, my
Why
lords.
can-
Then
can
on the
it-
18th to 22nd, we can hear.
would it be convenient for you to appear virtually on 28th of May?
Please, my lords. Is your lordships working on the 27th of May?
27th is a holiday.
It's a holiday here also. I was just
27th is
taking
a
a
holiday.
chance. Oh, 28th, my lords. I'll
28th. All
oblige.
right. Here, Mr. Sanjay Hegde, learned senior advocate for the petitioner, is present virtually. The learned advocate general who represents the state in this case is not available. A prayer for adjournment thus has been made. Let this matter come up for consideration on 28th of May. All right.